I tried a couple cases against this guy, and in both cases, during voir dire, he knocked his water cup off the table. So the first time I was like, oh, he just knocked over his water. The second time I'm scratching my head, right? This was deliberate. He did it all the time, everywhere he went. Because then he got to be kind of like Columbo, sort of like, oh, shucks, poor me. And he's a sympathetic figure now because he's clumsy.
This is RVA Trial Lawyers, Virginia's trial lawyer podcast, hosted by Sharif Gray and Niall Abuzaki.
We have a very special guest with us today. We have retired Judge Hammond, who sat in Henrico County for around 16 years in the Henrico County Circuit Court. Prior to that, she was at the Attorney General's office. She's also done big law and also clerked. Judge Hammond, please introduce yourself to our listeners.
Hey, guys. I'm Catherine Hammond, just another lawyer, mom, wife, all that good stuff.
One interesting view that you bring that we haven't brought to this podcast is experience from the bench. But before we get into that, let's talk a bit about your background. So I summarized that you were on a bench for 16 years, and you were also at the AG's office. What were you doing at the AG's office?
Well, it's an interesting story. I was sitting in my office with the door closed, and knock, 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 the chairman of the firm at the time, Bob Patterson, opened the door, and then menacingly, he closed it again. And he said, hey, we have a new attorney general. And I said, yes. And he said, well, he needs somebody to go over there and head up the civil litigation division. And I want to put you up for that. And I said, oh, Mr. Patterson, come on. I just got elected partner a year and a half ago. Okay, I'm just about to make some money. So I went over. I'd never met Jim Gilmore before that. And we had several long conversations. And then I ended up going over there, and it was very, very interesting, very exciting.
And when we talk about the civil section at the Attorney General's office, it is the largest section. And what departments did you head under this particular civil section?
Well, the way it was organized then was it was all tort claims against the state, which includes medical malpractice because we have the teaching hospitals, and tort claims for highway injuries, all those, employment law, so any discrimination case brought by a state employee, utility regulation over at the SCC, antitrust, which was usually a multi-state affair, consumer protection. We have a lot of consumer protection laws. And then the construction litigation was also in there. So each one of those sections had its own manager, section chief.
And Judge, I'm assuming you'd done all of that, right, before you took that job. Is that right?
Not hardly.
So how did that work, go into a position where you basically had to be a chameleon, right, and learn all types of new things?
Right. Well, I did all commercial litigation. So when you do business-to-business disputes, you have to learn a new industry each time you do it. So if you're representing a bank, you got to figure out how do they operate a bank, what matters to them, how do they give instructions, what's the back office. If you represent, like I represented a utility that operated a coal-fired generator in Florida, and the dispute was whether there was a breach of warranty about the turbine blade. So you had to learn that and talk to engineers. So you get to be a chameleon. That's what makes it fun.
Did you have a favorite job before you took the bench?
Probably being the law clerk to the judge. That was heady stuff because you're new, you don't know anything, and everything looks very glamorous. That was in New York, and my judge was very experienced, so he was very decisive. He knew what he wanted to do, so I could kind of tag along.
I thought I learned more clerking that year and a half or so I did it than I did throughout, most of law school and probably most of my few years I was in the JAG. It's amazing how incredible of an opportunity it is. I imagine when you were a judge, you probably had your own law clerks. Is that right?
Yeah, we do. We're lucky to have that. Where did you clerk?
So I clerked for District of New Mexico and then on the 10th Circuit briefly outside of Kansas City.
Wow. Was Virginia your home before you went to VMI?
Virginia was home. I grew up in Northern Virginia, D.C. area, VMI, UVA, then traveled around with the Army and then clerked and then ended up in Richmond.
Right. Interesting. Yeah, we have law clerks in Henrico. The county supplies that. Not every circuit court has that.
I just remember how important the role of the law clerk was. I mean, there were career clerks, term clerks, to the point where I thought without law clerks, it would be difficult to deal with the caseload, at least that my judge had. When you don't have a law clerk, that means the judge is doing everything, right?
Yeah, there's just ways around it. You probably end up ruling from the bench more and not writing letters as much.
Probably rely more on the lawyers.
Yeah, you can ask the lawyers to give you more authority. You can have your assistant call up the lawyers and say, the judge wants another brief on this particular issue. You have some authority when you're a judge.
Well, can you tell us a little bit, Judge, about that transition from, I guess you're in the AG's office and at some point you take the bench? What happened?
That was a joke when I said that. You have some authority when you're a judge.
That black robe is powerful, Judge. It's very powerful, especially for a practitioner.
So it's funny, I didn't take that as a joke, and probably the reason why is because I believe it, especially when we're trying cases.
You do.
Well, and even if I were to disagree, at the end of the day, the jury thinks the judge has authority. When we were in the Army, what was really something we had to wrestle with was I was a captain. The judges were typically colonels. And so if I got sideways with a judge, the jury's watching a captain get sideways with a colonel. That doesn't happen, right? So the colonel is assumed to know how it's supposed to go. I think the same kind of atmosphere is in a regular courtroom. The jury is looking to the judge as the authority. So if the lawyer is doing something and the judge doesn't like it, the lawyer is at risk of losing some serious credibility with the jury.
Interesting about the Army. Yeah, we don't have anybody above us in the chain of command. You brought up so many good ideas. I think in the courtroom, I like to think all three people are trying to get to a good result. So both lawyers and the judge. I think the judge in a trial should pretty much stay out of the trial. So I try very hard to have a poker face, don't react. Whatever the witness says, I just doodle on my yellow pad, try not to give away anything. Because you're right, the authority is in the institution. It's not me, Catherine Hammond, who has authority. That's not it. It's the institution that has authority. So that's why you have the robe, because you're just like every other judge. You are not an individual person who's making things up as they go along. And that's why the bench is raised in a lot of courtrooms, or historically was. You have the two flags there, and then you have the bailiff, who's usually part of law enforcement. So all of these things are to give the institution authority that would make it respectable. The judge has to not only have a poker face, but has to realize that this business about decorum and seriousness is to lend authority that people can have confidence. Oh yeah, the court works. I get it. It actually works.
Those are great points. Can we talk about a favorite subject I have? Voir dire. I've noticed that judges really like to have a heavy hand on voir dire here in Virginia. And I run into the situation where I had a whole plan for voir dire and the judge just wanted to move along. But I couldn't, I guess, object or argue with the judge because the last thing I want to do is my first impression to the jury is I'm doing something that this authority figure says is wrong. It's a real interesting dynamic, especially at the beginning of the trial, and especially considering how it's the time of the trial that the advocates and the court has the least amount of control,
and
right?
Judge, we talk a lot about voir dire, and as you're picking the jury, or you're excluding the jurors that you don't want, because you can't look at it as picking particularly. They're all on that jury pool. They're picking a side. As Sharif is saying, we're tiptoeing a fine line to make sure that we're not upsetting the court, or at least giving that impression to the jurors. And my experience and Sharif's experience, each judge has his own way. And the discretion is up to the court. But talking about voir dire, why do sometimes particular judges want to kind of control that process?
I don't know what to say for the other ones. You have to remember, I'm not in other people's courtrooms.
Yes.
Okay, but I remember when it happened to me. I'll never forget. So I identify with what you're saying because I can remember thinking, I got to ask these questions and I don't want to make the judge mad. I get that. I'm really glad y'all asked me on here because I love young lawyers. I listened to all your podcasts. They were all fantastic. All these people talked about it. John Shea talked about it. Russell Bowles talked about it a lot. And I heard all of y'all say that it's a really important part of the jury's introduction to you and your client. The statute says that the juror would be excused if he or she does not, quote, stand indifferent to the cause. It's not about where they live or their race or their occupation. It's do they stand indifferent to the cause? Couple things. I was going to ask you this question. I was going to say, let me ask you this. In voir dire, have you ever considered bringing up the jury instructions? These are the requirements that will be given to them.
For example, in a PI case, jury instruction 9.0, where it talks about damages and putting a number on intangible things like pain and suffering. Well, pain and suffering technically isn't in 9.0, but things along the mental anguish, bodily injury. Absolutely. Those are things I like to bring up in voir dire. One of your roles on this jury is going to be to come up with, should we meet our burden, the full and fair value of mental anguish. What are your thoughts about having to do something like that?
Right.
And that's a question that I certainly want to ask.
Right. So I think if you could tie it to a jury instruction. So if the judge says you need to move along, if you could say, Judge, the jury will be instructed on this issue at the close of the evidence. So I just wanted to let them know that it's not my idea about whether a police officer's testimony would receive more weight than somebody else's. It's in the law. And I didn't think that up. So I'm just trying to tie it to what their requirements will be at the end of the case. I
remember actually having a back and forth with a judge at one point. I said, well, Judge, I recognize that that is the instruction and you'll instruct in that. The whole point of this process, and I was polite when I said it, was, are they willing to follow that instruction?
But they don't really know yet, right? Unless they've been on a jury before. So really the question is not, can you follow it? The question is, this is a task that you haven't been given before.
Right.
So I just wanted to give you fair warning or advance notice that at the close of the evidence, you're going to be told that you can't decide the case based on sympathy or bias or speculation. So that's why I'm asking some of these questions that might be a little bit intrusive. Anyway, going back to how can you get around the judge? I think if you could tie your question to an instruction, that would be somewhat persuasive because judges respond to what's your authority.
I like that.
Yeah.
I like that.
And another thing is, well, you have to ask around, right? Ask your buddies, what is this judge's habit during voir dire? So you know. And then if you can say something peculiar about the evidence, so maybe somebody has a disability or something that you want to explore. What if you said to the jury, now one of the witnesses in this case will be a person who didn't graduate high school, and actually he doesn't even know how to read or write. Do you feel like he gets the same consideration as somebody who did go to college? Yeah. No, so tie it to that.
Well, what you're referencing, Judge, is a danger point. The way that I think now, and I view voir dire in many respects, is we're looking for the weaknesses in our case, and we want to vet that with the jury before we even get started with the trial. And I think that's perfect. One thing I've started to do is we have a bench brief that has 5 different points that I file in advance, and it lays out the law on voir dire, because this is my educated guess on why I think voir dire can be limited. I think that the traditional voir dire that judges are used to is, all right, who knows so-and-so? Who has ever been in a car crash before? Has a relative who's in law enforcement, such and such. And so judges, I think, are used to that. So yeah, hand raised, yes, hand raised, no, whatever. And then when lawyers do something that deviates from that, and this is just a guess, I think the concern is that the judge might be thinking, oh, wait, this is different. Are they trying to persuade? Are they trying to start advocating for their case? Whereas if they just stick to what you had mentioned a few minutes ago, Judge, the statute, which defines a standard, whether a juror can stand indifferent to the cause, then it should be fine. I just think that once it gets outside that traditional just hands up and down, I think sometimes judges get a little antsy. And then also, of course, the time constraints, right?
Well, this is the thing we tried to do at one-day trial.
Right.
Yeah.
Going forward for me now, I don't set one-day trials. But at the same time, from an advocate standpoint, I also don't want week-long trials if it doesn't need it, because you want to be respectful of the jury's time. You want to be in and out, and you want to move, but you also at the same time don't want there to be such a time crunch that you're not able to actually do a good job in some of the important trial phases because you're worried about getting out of there in one day.
You're talking about voir dire, Judge. Yes, you want to try to tie it to the jury instructions, but a trial attorney is also trying to get his weaknesses out and up front, and then color it the way they see it to the jury. I had a 5-day jury not too long ago, and I had a 7-year-old child sex victim. And I knew that she could easily get tripped up by defense counsel. One of my questions, which I know they would work in some courtrooms, but not others, I looked at a particular juror, and I was like, Miss Smith, I want you to look to your right at Mr. Johnson and tell him the last time you had consensual sex with your husband, a man that you loved. And then I was like, ma'am, that's a rhetorical question. I'm not expecting you to do that right now, but can you appreciate how difficult that is in a room of complete strangers to share intimate details about sexual interaction with your husband? She goes, yes. And I was like, well, what if you hear from, instead of an adult, you hear from a 7-year-old child? And then everyone was like, oh God, you saw the reaction from the jurors. And I'm like, what if it wasn't consensual? And what if the child doesn't even have a frame of reference to what it means to be touched in a particular way? So the reason why that line of questioning I wanted to ask, and I did ask, and I'm sure some judges don't allow that, and I can see why, and some judges did, or do, and have, is because I have to prepare the jury that you can't expect the 7-year-old to just get on the stand and articulate a story to you like you expect someone to that hasn't gone through trauma and so much anguish. So we try to, in a way, as a trial attorneys, to get the weaknesses out in voir dire. And that's the difficult part that sometimes judges don't want us to do. And then there's that back and forth, and then you tend to get steered by the court.
Yeah, but Judge Hammond, I do think is right. It still has to be tied to an issue in the case. In that situation,
credibility
it is
of a
tied
witness
to an issue in the case.
To the
right?
credibility of a witness, and that's a jury instruction.
Right. So it is tied to it. It's just interesting that I go to a bunch of these national trial conferences, and you hear California, Florida, week-long voir dires and all that. And I'm not necessarily advocating that more voir dire is necessarily better. It may not be. But it's just interesting how here in Virginia, we're just so used to it being so concise and so restrictive, when really the law, at least the way I read it, doesn't have time limits, doesn't have this restrict. It's actually pretty broad. So it's just interesting how Virginia jurisprudence has developed in a way where voir dire is just not a large part of the trial, which I think is a mistake. I think it's an incredibly important part of the trial.
So now we're talking about voir dire, Judge.
And we already got lost.
No, we're gonna talk about the jury trial. You've presided over many jury trials. Let's talk about jury trials and what makes our country special and our judicial system special compared to other countries.
We can't talk about voir dire anymore.
Oh, we can. Please do.
We could spend the next few days talking about voir dire.
Well, we follow your lead.
No, only other thing I was going to say is you can ask for some kind of audience with the judge beforehand. I mean, if you have something, say, Judge, I know you don't like me to use up a lot of time. I don't want to use it either, but there's something about this I got to find out. This is what I got to find out from these jurors. But that means you do have to have some particular thing. So
no, absolutely.
I mean, voir dire is your introduction. That's when they see you and they're like, I don't know, that guy looks kind of shady to me. It's a very important part. I heard a couple of your guests say it's the most important.
Oh, I think it is. I spent the 3 weeks at the Jerry Spence thing, and we probably spent 80% of those 3 weeks on voir dire. And what was interesting about their philosophy, and I'll be quiet here in a second because I want to hear with your perspective, Judge, on presiding over the many jury trials that you did. But what was interesting, at least at the Spence College, was it wasn't about finding bad jurors and kicking them off. It was about building a tribe.
Correct.
I don't believe that people show up to jury duty and they're just bad jurors. I think people have different opinions, and some people it just may not be the right case for them to be a juror on. But oftentimes I think if the lawyer can build a tribe, build their credibility, develop a little bit of trust and rapport and vet some of their issues, they're off to the races.
Yeah. Okay, so here's a good one. I tried a couple cases against this guy, and in both cases during voir dire, he knocked his water cup off the table. So the first time I was like, oh, he just knocked over his water. The second time I was scratching my head, right? This was deliberate. He did it all the time, everywhere he went. Because then he got to be kind of like Columbo, sort of like, oh, shucks, poor me. And he's a sympathetic figure now because he's clumsy.
Yeah, that's funny. And could he do it genuinely?
Yeah.
Wow.
So, never forget the theater of the court. The theater.
It's powerful.
Of the court. Yeah.
It's fun too, right?
Now, don't do it because I told you.
Next time I see
I'll have Judge Harris calling me up saying, what the heck?
Yeah.
Next time Judge Shakur is spilling his water bottle.
That's right. That's right. Yeah.
But the jury trial and the jurors, that is the significant issue. That's why you are called trial lawyers, is because of the jury. And I was talking to Niall not too long ago about how not every country has this. You don't have this in other countries. You don't have it in Italy. You don't have it in France. You don't have it in Mexico. This is an American institution now, even though we learned it from England. I think, and John Shea touched on this in his interview with you, this is the most pure form of democracy that can exist. Why? Because of participation. When you vote, that's participating, but you're just one ballot, right? But when you're one of 12 or one of 7 and you have to participate, you have to take your oath, you have to listen, and then you have to work together to reach a consensus. Even countries that have a jury trial, it doesn't have to be unanimous. And I think in civil in the U.S., maybe half or 2/3 of the states, it doesn't have to be unanimous either. But anyway, if you have to get all 7 people to agree on liability and damages, that means you're sharing, you're communicating, you're participating in what? In this institution that I was talking about with the flags and the robe and all that. It's amazing watching them work together. They never met each other. They don't live in the same neighborhood. Their kids don't go to the same school. They have no point of reference other than that they are citizens and they live in this locality. They get in there, and then by the time they leave, they're like best friends.
Yeah.
To me, if you say, what is justice? Remember during the summer of George Floyd when people said, no peace, no justice? I started wondering all summer long, I wonder what people think is justice. I wonder what that is. I think having those 7 or 12 people participate, that's justice.
Very well said. We got Ben Rand walking by us right now.
You want some wisdom?
We'd love some wisdom. Give us some wisdom, Ben.
It's Veterans Day weekend. Go home.
Veterans Day weekend, go home. We're not supposed to be working.
Judge, it's a pleasure always.
All right. We'll see you, Mr. Rand.
All right, see you.
Bye-bye.
Yeah, take care, brother.
All right, take care of the wall, Paul.
All right.
The jurors, they all seem to try really hard. They do.
And Judge, you said it, and Sharif touched on it. You're building a tribe. It becomes a tribe. So you start the building process, but it becomes a tribe at the end of the trial. And many jurors exchange contact information. Many jurors keep in touch with one another. And how do I know that? I actually contact my jurors, and I try to do that after each and every jury. And the last jury I had, the jury came back fairly quickly, and I was like, I want to call them, see what worked and what didn't work. And the reaction that I got from them is that they just all felt so good. They were like, Mr. Abuzaki, we felt so good getting a bad guy off the street. It was a murder case. And I was like, well, was that shared by all of y'all? They were like, as soon as we walked back and we were talking about the video that you played and you kept on playing, we just all shared that same sentiment. And then I went home. One of the jurors, who's a restaurant owner here in Richmond, he goes, I went home and I started telling my family how good I feel. And you gave me a feeling that I've never felt before. And I was like, well, I didn't give it to you. You gave it to the community. That's what you do. You represent the community. So Sharif talked about building that tribe. They become a tribe. And it's in that deliberation room that tribe is formed. It is so powerful. What we lose sight of, and you touched on it, Your Honor, is the fact that jurors, they don't know anything about this case. And we've experienced it where someone gets the call that they're going to be on a jury pool. They're calling their friends, they're calling their attorneys, they're talking to the significant others. You have to empathize with them. You have to walk with them as a practitioner. The night before going to sleep, they look to their left or right and talk to the significant other about it, assuming there's a significant other in that picture. The drive to work, there's a lot of anxiety, there are a lot of emotions. They come in with a book. They don't know what to expect. They don't know when they're going to be able to contact their family members. They don't know what kind of case it is. Is it civil? Is it criminal? And then they're seated there. They're nervous. You talk about spilling that cup. I make sure to let the jurors know that I'm a bit nervous too.
If you can do it authentically. Because if you can't, then they'll see through that.
But Sharif, if you are a trial attorney and you love what you do and you're passionate about what you do, you have to be a bit nervous about what you're doing, right? Because that kind of fuels what I do as a prosecutor. And I share that with the jury. And as soon as I say that in voir dire, you see a slight uplift in their face. They all just kind of smile back at me and lock eyes. It's powerful. That jury and that tribe and that deliberation is so powerful. And I agree with you. That is the purest form of democracy.
I mean, they don't always get it right. We don't have a perfect system, but I think we have the best one in the world.
I agree with that wholeheartedly. Even though we're seeing a lot more jury trials today and we're working, and they're a lot harder because you have to educate and you have to take that human element into the process and into prep. Bench trial takes 20% of what a jury trial takes, even though I treat all my cases as a jury trial, but still, you got to educate the jurors.
So, Judge, from your time on the bench, can you share with us some things you thought lawyers did well, lawyers didn't do well? I'm sure you've probably got a whole book you could write about the things you saw that worked and that didn't work.
There's so many things. The judges give a little talk at the bench bar conference and all that with tips, and I'm sure you're already doing great. You already know what you're doing. Just keep doing it. If you like it, then you know you're doing something right, because you wouldn't want to go in there and do it again otherwise. You know you have to listen. It always amazed me when somebody asks a question of the witness and the witness answers, and then you can tell that the lawyer didn't hear what they said because of what they say next. Also, they don't really know what people are talking about. Like frequently in a criminal case, they're talking about where somebody was. Where were you? Where did you live? Where did you live? Keep asking, where did you live? The witness will say, well, I stay with my aunt. Well, that doesn't mean he lives there. He stays with his aunt, like sometimes. Right? Because that's how a lot of people live. So you gotta have a broad filter. You can't have just stereotypes about how people are. And then I think when people say be yourself, it just depends on what you're like. Some people are funny. I never was. I always had to just do straight arrow, like straight ahead. I couldn't do that funny stuff.
If you're not well liked in the community, then you can't be yourself.
I guess not, yeah.
Well, see, when I went on the bench, they had already had the rookie school for judges that year, because they do have a little school for new judges. But I missed it. So I was on the court for a whole year before I got to go to it. It was the following May. Lots and lots of mistakes in that year. But when I finally went to it, they had this guy. His name was Ben something. He was real animated. And he talked about how to act in the courtroom and how to handle the lawyers and how to make sure everybody's on board the ship. And he said this one thing. He said, if you care more about being liked than you care about being respected, you are in the wrong job. And you should consider resigning your commission. So I think you do want to be liked by the jury, but mostly you want to be respected.
You want to be trusted.
Yeah. So why do they respect you? Okay, number one, passing the bar is not just like, whew, I made it. That means that you have command of an esoteric body of knowledge. If you're not admitted to the bar, you don't have that. So you have command of a very precious thing. And I think you should be respected for that. This is a great profession. This is people who are knowledgeable, competent, who strive to be better.
You touched on something, brought back a quote that a prominent attorney here in the Richmond area once told me. He's like, Niall, you can spend your whole entire life trying to gain standing in the courtroom, and you can lose it in 5 minutes. And he's like, every time you step foot in the courtroom, you're building that standing before the bench. So keep that in mind. And that practitioner is Craig Cooley.
Right. And that kind of goes back to what you were saying, Sharif, about having enough time to conduct the proper voir dire. So if you have a relationship with the judge, it's going to be easier, right?
Right.
But if you have to go to another court, like, oh my gosh, I tried this jury trial in Giles County. Do you know where that is?
I do not.
And you lived in Lexington for a while.
I do. I prosecuted in Montgomery County. So,
lived in Lexington. You mean behind bars?
Behind bars.
It's called VMI.
That's right.
Yeah.
The barracks.
So, that's right.
Well, anyway, it's way, way down in the mountains. And the court was in a town called Parisburg. And the first thing that happened in the trial for opening is the plaintiff's lawyer went first. And he said, I'm John Kennett. I'm from over in Roanoke, not that far away. Over there, that's Miss Hammond. She's from Richmond. So first thing he's going to do is say, Catherine Hammond does not belong. She is the other.
She's the outside.
Yeah. So if you have to go to another court, I think you just have to communicate with lawyers in that circuit and say, can you give me any hints about voir dire? What should I do? How can I meet the judge beforehand? Would he take to that? Because that trust doesn't come automatically.
It certainly doesn't.
But, judges are more approachable than people realize.
Judge, I'll tell you, I've experienced that sentiment in smaller jurisdictions. When I prosecuted Montgomery County, our juvenile domestic relations court judge, at times I have my office door closed and there's a knock and I open it and it's our judge. And he's like, no, you got a second. And he would come in and sit, we would talk for about 45 minutes to an hour. Same thing, if I have some free time near the end of the day, I would walk up to the circuit court and go to the back and I would sit down and talk to either Judge Turk or Judge Long. But it seems like now in bigger jurisdictions, in our mind, they're not as approachable. And clearly seems like it's a fallacy.
Yeah, I think you should just assume that they're lonely. That was a joke too. You guys are laughing.
Well, Judge, guess what? No, I am going to assume that. I'm going to be hanging out in chambers next week.
No, I think if you have any chance to just go back in the back and say, hi, Judge, how you doing? I have a trial coming up. I haven't tried a case before you. Anything you want to warn me about? I don't think that's a bad thing to do. Now, you can't do the ex parte. It depends. Some are very stuffy. That's okay. Everybody's different. And some are more approachable. But that was the best thing about Henrico. We had the cafeteria. We all ate lunch in the cafeteria every day. The district court judges and the circuit court judges, almost all of us. And then who would come in and sit down at the table? Jeff Everhart, Craig Cooley, Tom Bondurant, bless his heart, Dick Glover, somebody who's on the board of supervisors. They're just all getting their sandwich at the same time.
That's awesome. Henrico really is a special jurisdiction.
Now they close the cafeteria.
Wow. Yeah, so we can deduct a few points for that. But even without the cafeteria, the judge is there, the CA's office, the defense bar, there's a lot of good people there. And it's a nice place to practice.
Thank you.
Now, Judge, when I was there, I remember one of my colleagues was very heavily involved in the drug court. And in doing my research, preparing for this interview, I saw that you were the one who started the drug court in Henrico.
I did start it by myself.
Right.
Yeah.
No, that's what I thought.
Yeah, and then when Judge Hicks came, he wanted to do it.
Well, can you talk a little bit about how the drug court came about? It's incredible to see the results it's had over the last decade or so.
Oh, yeah. Well, there's over 4,000 drug courts now. When I retired early. I was 61 when I retired. And I got on the faculty of the National Drug Court Institute. So we go and train courts on best practices because there's research every year. This is the best thing the Department of Justice does in Washington, in my opinion, is they have this research arm that can get all the data together. For the longest time, there were 4 judges in Henrico who'd been together for a long time. So it was very, very stable. They'd all been together. They all knew what was going on. They all did things a certain way. No disruption. And then here comes not only somebody too young, not only somebody who never did any criminal work outside of traffic, but also a woman from a big firm, so that's not usual. I was the disruptor. I tried everything I could do not to be disruptive. I was very deferential, very polite, always asked, how do you do everything? But what can you do? So then a few months later, here comes Gary Hicks. So it was 2 against 2. We had it even. Before that, it was all forward together, then 3 and me, and then Gary and I. No, I'm just kidding. Everybody went along with it. What happened was when Gary and I came, We just couldn't figure out what to do about all the show causes. It was unbelievable. Somebody tests positive, they come back, you give them 3 months, then here they come again. And it was just over and over and over and over. And we were like, is this really, if you're used to solving problems, when I was a lawyer, I was supposed to solve problems. Judges don't do that. But I had a hangover for being a problem solver. So we thought, this can't be right. We said we should do this drug court, but only for probation violations because we had so many. See, we didn't need any new cases. Now, Chesterfield was doing it, but they were doing it like 251, like first offense. We said, no, we want the worst of the worst. We want the people who are chronic recidivists. That's what we want. And the only reason I bring that up is because the truth is the reason we took only probation violations is because we had so many of them. Part of that was how District 32 handled probation. Like they reported every single positive urine. Now, not everybody does that. And of course, the laws changed on the sentence for that. However, we had so many that we thought we don't need to go to new charges because we're never going to run out of probation violations. So now I just have to say this one thing. That was in 2000. We got our first grant to implement it in 2000. And here we are in 2023. And guess what the research has shown over the last 22, 23 years? That's your target population. You should not give the deepest, most expensive resources to people who have one possession charge. That's not who needs it. The people who need drug court are people who are actually diagnosed substance use disorder, not just because they had a glass stem in their pocketbook when they got stopped for a red light. Chronic substance use disorder, failed treatments in the past. That's your number one candidate for drug court. If you have a failed treatment experience in your past, that means you're an ideal candidate for drug court. We happened on that by mistake, but I'm very proud of it. So Gary and I, the hardest thing we had to do is get all the buy-in. So we had to go to Toby Vick, Commonwealth's attorney, and say, we want to do this. Hard no. And then we had to go to the sheriff. He wanted to do it. We had to go to the county manager. We had to go to probation. First thing you hear is, we don't have the money for that. We don't have the money for that. So you have to work around it.
It's still going on in Henrico until today, Judge, and the seed that you planted, we're still reaping from it.
Yeah. Well, Judge Marshall and Judge Johnson put on a dinner for the 20th anniversary at the Cultural Arts Center. So we all went, and it was fabulous. So it was 20 years. But the most crazy thing that happened at the dinner was they had different participants or graduates come up and speak. Were you there?
No, I was not.
Okay. So this woman came up, and she gave her talk, and she said, she graduated such and such, was pretty recent, like in the last 5 years or something. And she looked over at my table and she said, and Judge Hammond, I am so happy to see you. You're not going to remember me, but the reason I remember you is because you let me out on a furlough when my daughter graduated high school. I wrote you a letter and I said, my daughter's graduating. All I want is to be able to go to her graduation at the Siegel Center. And I gave her a furlough. So she's shouting out to me 20 years later, because this wasn't a drug court person. This was just on her regular criminal life before drug court. We were hugging and crying, and she said, I can't believe. She said, that was the most important day of my life that you let me go to that.
To you, it was a signature on the bottom of a page. To her, it was the most important day of her life.
That's right.
And sometimes we lose sight of that stroke of a pen of a judge is so powerful.
Yep.
How, Judge, after being on a bench for 16 years and seeing that hamster wheel, inmates in and out, day after day after day, how do you keep yourself from being jaded and still appreciating that I may do one thing and that someone may be most important day of their life? How do you keep that in check? Because it's hard after seeing failure after failure.
That's the job, to treat every single person as an individual, every case as a single case. That's the job. That's what you signed up to do. So how do you do it? I mean, different people do it different ways. I had a little thing I did. I took over Judge Culp's docket. And so I would get all of his cases back on show causes. And I saw he had a yellow sheet in each file. We had paper files. And he'd always put the name of the person and then the charge and the plea, GP or NG, and then were they convicted? Because you just need your note for if you have them back again and so forth. So I just took his habit. Judge Harris does it too. Judge Tidy did it too. But so when I'd go through my files the day before, so I got a stack of files there, and I go through them, and I'd put my yellow sheet in each file. So I open it up, I see the indictment. That's the first thing in the file. And it's got the person's name. So on the top of my yellow sheet, I would write their full name. So it wouldn't say Sharif Gray. It would say Sharif Jonathan Gray. I wrote the whole thing out.
You can use Niall's name if you'd like for the indictment.
Yeah, that one's coming, right? Yeah, that one's coming. So I always put the middle name. Because why? Because I thought somebody cared enough when this little baby came to give him this middle name, or her. That was a special person then when they were named, and it's a special person now. And I got the whole name out there. I heard another judge, Jane Roush, she was a circuit court judge in Fairfax. She told me that every morning when she was getting her robe on, what she would do is she'd stop for a minute by the doorway and she'd say to herself, okay, Jane, don't phone it in. When you go in there, it's just another day for you. But for the people out there, this is the biggest day that's going to happen for them, at least in the next week.
If not
their life.
Next few years of their life and their family's life.
Well, Judge, how do you sentence somebody? Because there's so many factors that you consider when sentencing, but let's say violent crime guidelines or who knows what, 8 to 15. Where do you fall? What do you do?
It's an impossible question to answer.
I know.
It's impossible.
Well, welcome to the podcast.
Yeah. I mean, I was hoping you wouldn't even ask me, really. It's the hardest thing. And it makes you crazy. Did you ever know Judge Nance in Richmond? He's gone now. When I first went on the bench, I knew him a little bit because I had tried a couple cases in his court. But we were standing at the judicial conference, and he said, so, how do you like sentencing? And I said, haven't done that much of it. And he said, well, your whole paycheck is for that one thing. That's what you're getting paid for. And oh my gosh, we didn't have plea agreements because Judge Culp and Judge Parsons, there was a basic cultural philosophy in Henrico that the sentencing is the judge's lane and it's not the prosecutor's lane. It's not the defense attorney's lane. They can weigh in, but the sentencing has to be done by the court. Plea agreements were discouraged. And I didn't really catch on to that the first few days because really there was a sort of an agreement, but it wasn't written down. But they'd sort of say, well, Judge, we think the middle of the guidelines is probably. So we do it like that. But it's real easy if it's a terrible crime. It's real easy if it's a nothing crime, right? But there's robbery and then there's robbery. There's robbery with a weapon and beating somebody up. And then there's robbery with holding a pencil in your pocket that looks like it's a weapon. And it's the first time they did it. So what is that? Is that 1 year? Is that 4 years? It's still robbery. I don't know the answer. I used to always go ask other judges. I'd go ask Judge Parsons. I'd ask Judge Harris. I'd ask anybody. And he'd say, well, what are you thinking? I said, well, it's probably somewhere around 3 to 6 years. And they'd say, yeah, that sounds about right. What is that? That's a big difference. That's a lot. That's twice as long, 3 or 6.
And Judge, as a prosecutor, I often question when I am making an offer, what is 25 years going to do that 20 years can't? What is 40 years going to do that 20 years can't? And I struggle to find an answer.
Yeah, there's not many things that take 40. I mean, 40 years, that's pretty high.
When it's a heinous crime, it's easier because then you're like, well, they killed someone.
Yeah, some things you just forfeit your right to be out here.
Without a doubt. And then more recently, the court looked at the Commonwealth and asked, well, Mr. Abuzaki, what do you think he deserves? And I couldn't come up with a sentence, even though I know this judge likes a particular number from the Commonwealth. And my victim was paralyzed. I was like, Judge, he's serving a life sentence. But not only is he serving a life sentence, his mom is also serving that sentence with him. His brother is serving that sentence with him. His father is serving that sentence with him. The community is going to be serving that sentence with him. And then judge looks at the defendant and gives him 48 years of active sentence. At first, I felt like, hey, this may be a bit too harsh. But then thinking about it, I'm like, well, it's not. It's not. It's, you go back and forth on it. And there are days when I'm like, no, what if you got 20 years? Would the deterrent aspect of the punishment and rehabilitation, would that have been served? That's a tough question. But I guess that's why y'all get paid the big bucks.
Yeah.
That's right.
It's really tough with drugs. And most crimes, there's some kind of drugs with most crimes.
One thing that I do find interesting is sometimes I've seen courts go above the recommendation of the Commonwealth. I've always had a little bit of trouble with that, considering that the Commonwealth is the one who investigated the case, brought the case. And while I recognize the judge has the discretion to do what they think is appropriate, but if the entity bringing the charge says, we're not looking for anything more than this, and then the court goes higher, sometimes I take a little bit of issue with that.
I can understand that. I mean, there's a lot about the case that we never know. We only hear a little slice.
Well, you did quite a bit of good, and that drug court is still helping out so many people.
One of the things also is bail applications are pretty interesting too.
Yeah, we got the presumption of innocence, yet also you got to weigh the risk to the community.
I had been there about 6 months, and this man came in, and I won't name his attorney, but I do remember it. He said that he wanted a bond, and he'd gotten one from Hanover. So he said, we were in Hanover yesterday, and he got a bond in Hanover. So if you give him a bond, he's going to get out until the trial. And I did. And then that night, my husband and I were watching the 11 o'clock news, and there he was on the news. He'd been out of my courtroom maybe 10 hours.
Oh, wow.
It was pretty bad.
Yeah.
But now, I'll tell you one thing. The drug court is great, but the drugs that we were dealing with when we started that weren't the same. Towards the end of my full-time judicial life, it got to be where if somebody didn't come back and you say, well, he's released, he had the date, well, he's not back because he's dead. I can't tell you how many times I've heard a case where the person died between the time they were arrested and the court date.
Overdose.
Yeah.
That's an argument often made, Judge, to defense attorneys when they want their clients out after either they overdosed or they've been charged with possession of heroin or fentanyl. I'm like, look, you may win the battle and they may lose their life. You may get them out on bond, but if...
Well, that's a big controversy in the drug court movement because you're not supposed to be...
It's not a guardianship, right?
Correct.
But what's interesting, if I remember correctly, when you're evaluating harm, it can also be to the defendant, right?
That's the argument for a prosecutor. I represent the community. The defendant is part of the community.
But in Virginia specifically, though, there is a carve-out. The court does consider risk to the defendant themselves, right? Whereas federal court, if I remember correctly, doesn't have that. And that's where your argument about the community comes into play. But then there's a tension of, well, we are a criminal court, right? Like, we're not your parents.
That's the tension. Yeah, it is in the statute. So you end up like people staying in pretrials. They're remanded for such long time. And it's a tricky thing.
Yeah, it is not easy.
But you all know your law.
I guess we put on a good perception. Perception's everything. So.
You read the statute on bail. I'm impressed.
Well, funny. Now I remember we were working together. What did we call it? Walk the dog, right?
Exactly.
Whenever you're in court trying to make an argument, you got to go back to the basics. What does the code section say?
Exactly.
Right? Let's put the code section up so everyone's on the same page. Let's make sure everyone has a tabbed copy with the highlights. Then let's go to the case law.
I love that.
Us lawyers love to make things complex. And I think really at the end of the day, if you're going to do a good job, you got to dumb it down and make it simple. Just make it simple. Nothing's really that hard as long as you're able to break it down into bite-to-size chunks. And if you make the decision easy for the court, then you've done a good job for your client. Your motion is organized, it's well written, and then your presentation is organized. You're making it easier for everybody because judges, they want that guidance, right?
Oh, absolutely. Absolutely. Mm-hmm.
So Judge, usually Sharif brings this line of questioning in the end of a podcast, and that we have practitioners that listen to it and also law students. For young attorneys, the view from the bench, what advice do you give young attorneys or law students?
Number one, what you just said, read the code, walk the dog, is how you put it. Ask questions. Go to somebody else in your office. Go to a networking. Ask people. When you're young, people want to help you. I love young lawyers. Most people do. They want to help you. So ask a lot of questions. Don't be afraid to be dumb. Just say, well, what do you do then? What do you do then? I cannot understand why people don't go in the courtroom and watch. I used to go and watch. You can do your work at night if you have to. Even the law clerks don't go sit in the courtroom that much. When I worked for Judge Bryant, I went in the courtroom every single day. Even if I had to write something, I would just do it later. Of course, that was at Foley Square where we had all these amazing, famous trials going on. There was an antitrust case against the NFL that was going on. That was really something. Anyway, what else would I tell them? Well, you got to do all that eat your vegetables stuff.
That's right.
Yeah, you can't just work. I think if I were a new lawyer, what I would first do is I would join one of the bar groups. So you can either join the Richmond Bar Association, Henrico, Chesterfield Bar, or you can join the VBA, VADA, VTLA, one of those. Get on a committee, because as soon as you get on a committee, you will get to know people in a cross section. You don't want to just know people who do what you do. And then your web starts to grow out and you get cross-pollination and everything. I think the first committee I was ever on was one that put on a moot court competition. And I got to know several lawyers that I ended up then having cases against. And it was so different because you knew them already. So I would join some bar committees.
The Inns of Court's actually a great organization for that purpose. Judge, it's been a pleasure having you. It's not often that we're able to sit down with a judge for this long and get to hear about all your experiences. Now, the one thing that we haven't touched on is what you're doing now. You're serving as a mediator, right? Yeah. And correct me if I'm wrong, but you started your own company. Is that right?
Oh, no. It was started by a judge in Harrisonburg.
Got it.
I became owner of it 6 years ago, but he started it in 2007. Okay. So his idea was that he would start a mediation group of all retired circuit court judges. And we're kind of laid back. I think we all have a sense that we already peaked. We're not like trying to get more status. But we all have this same idea that we can use our experience to help people. It sounds kind of goofy, but you have all this experience. You're not done yet. And if you can help somebody out, I do a lot of divorce mediations, which cracks me up because I hated the whole subject. My mom was divorced twice, single mom, running out of money all the time. I never want to have anything to do with it. I said yesterday with this couple for 10 or 11 hours, can you just get to come on now, you're almost at the finish line. You're almost at the finish line.
It's the hangover, problem-solving hangover.
Yeah, that's it.
She's still struggling with
That's
it.
right. Yeah. Lawyers, we aren't good at retiring, are we?
No. Yeah. It's so boring.
That's right.
It's so boring. Just take a long trip. I just came back from a 3-week trip. I was telling Niall I went to this crazy places. I went to Albania, Montenegro, Macedonia, Serbia.
Oh, wow.
Yeah. So you can take a trip, you can sit on the beach, but you're going to get bored after a while. But you guys are the forefront. So, the baton is being passed over to you. And I'm so pleased. I'm so excited that this next contingent it's always coming. And you'll be able to lend a helping hand to people coming along behind you. And this is such a good profession. It's such a good profession.
Judge, we appreciate you so greatly. We will do everything within our power not to drop that baton and then to pass it down to the next generation as well. Thank you.
Thank you.
Thank you for listening to this episode of RVA Trial Lawyers, Virginia's trial lawyer podcast. For more episodes, check out rvatriallawyers.com.